permission, nor have they challenged the notification under 5/6/2024. Therefore, our case is in respect of respondent number 6, 195 days notice is required to be issued as they are continuing taking
afresh
benefit.
now. Afresh now.
Yes,
195 days notice afresh now.
Afresh now. The orders
until then the present management will continue.
It will continue because they are getting the benefit under this notification. They want the benefit under this notification, but they don't want to comply with the other condition.
Huh.
It is this which is referred to in granting the interim order.
Yes.
That is first aspect.
So, according to you, the proceedings under 13 were never taken up prior to.
No, whether they had taken up or not taken up will not matter at all, unless they file a writ petition and get a permission to continue it from that stage, as was done in respect of some 4 or 5 societies. They came up with a writ petition pointing out this works out very operative against them. Then your lordship may kindly have
page 32 of the statement of objections.
Please, my lord. Your lordship
This
may
kindly see Devdas or order.
Yes, my lord. In that, my lord, your lordship may kindly turn to
It is specifically clarified that although the returning officer had not issued calendar payments insofar as so and so, nevertheless, the process of election shall commence on the stage where it is halted only insofar as the aforesaid one cooperative society. What was the general direction given? From where it stopped, it shall start.
That is the unfortunately or fortunately, government by this notification had overruled it. It said whoever has taken benefit of the notification under 21(3) will have to do it afresh.
All right. Yes, respondents. Sir.
Your lordship kindly ಆರ್ಡರ್ನಲ್ಲಿ ತಾವು ಇನ್ನೊಂದು ನೋಡ್ಬೇಕು.
ಯಾವುದರಲ್ಲಿ?
ದೇವದಾಸ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ನಲ್ಲಿ.
It starts at page 23.
Please, my lord. In that, your lordship may kindly go to para 4. There was a query by the Honorable Court. Printed page 19 of the order, my lord.
Yes.
Please, my lord. However, Shri so-and-so appearing for the petitioner submit that work involved as contemplated under 13(d)(2) of the rules would be around 60 days, and accordingly, even after 6/6/24, benefit at para number 1 of the notification dated so-and-so needs to be extended till the actual holding of election. It is further submitted that last of the polling date would be 7/5/24. In order to address grievance of the petitioner, it would be appropriate for the government, if otherwise it is practicable, to commence the preparatory steps leading to the polling. However, such aspect is a matter to be considered by the election authority and the government. The grievance, as pointed out by the petitioner, is a common grievance in many societies, as well as that there exists a similar factual context. The state to take an appropriate stand, release the matter on so and so. Copy of this order to be furnished to the council appearing for the election authority and the government advocate. In view of the direction issued by this court, the Additional Chief Secretary, Department of Cooperation, made a written communication dated 23/5/24 to the State Cooperative Election Authority, clarifying that it would not be permissible to permit continuation of the election process during the operation of the model code conduct. Nevertheless, it was also clarified that if the process of election were set in motion in accordance with law, having regard to Rule 13D, 5D3 of the rules, in all such societies, process will be permitted to be continued from the stage when it was interfered. This was the answer given by the government in an earlier petition. Then, in spite of such an assurance given by the government, nevertheless, in the impugned government order dated so and so, it is directed that elections are permitted to those societies where calendar of events are issued by the returning officer, and other societies are to restart the election process after considering year so and so and complying with 13D rules. Learned therefore submitted that state government should not be permitted to approbate and reprobate according to its convenience. However, during the course of these proceedings, government issued a corrigendum to the order dated so and so, clarifying its earlier government order. It has been clarified that in all cases where the process of election were commenced and halted on 21/3/24, it would be permissible to continue from the stage where it was stopped due to issuance of notification at the hands of the government. Nevertheless, so and so submitted that position again remains that only in cases where returning officer had published the calendar of events, it would become permissible to commence from the stage where which elections process was halted. Learned senior counsel would therefore submit that, having regard to the fact that petitioners had earlier approached this court and a specific direction was issued by this court in respect of petitioner societies, it was clarified by the state government that it will permit the continuation of election process in respect of petitioner societies from the stage when it was halted. This court should clarify the corrigendum order so that process of election in so far as petitioner cooperative societies are concerned shall proceed from the stage where it was halted. Having regard to the submission made by the senior counsel and having found that in so far as petitioner societies are concerned, specific directions were issued by this court seeking clarification at the hands of the state government, and the state government through additional chief secretary of the corporation has specifically stated in the communication dated 23/5/24 that petitioner societies will be permitted to continue from the stage when it was election process was halted. Necessary directions are required to be issued. At this stage, AGS admits that if this court were to issue directions clarifying the government order, including the corrigendum dated so and so, benefits should be restricted only to the cooperative societies in these petitions, that is, 4 societies named therein. And so, the submission made by AGA is accepted. Consequently, writ petitions are disposed of with a specific direction to the State Cooperative Election Authority, Regional Commissioner, Bangalore Division, and Apex Cooperative Societies Election Officer to continue the process of election in so far as the petitioner cooperative societies so and so from the stage when it was halted in view of the issuance of model code of conduct and government order dated so and so. It is specifically clarified that although the returning officer had not issued the calendar of events in so far as the petitioner cooperative societies, nevertheless the process of election shall commence from the stage when it was halted. So, some of the societies approached the court challenging the notification dated 5/6/24. They were given permission as a concession by the state government. In this case, respondent number 6 has not sought for any such permission. It is bound by this notification.
May I submit?
That is with regard to this point, my lord. In WP 103590. Prayer number C may kindly be seen.
Exclude.
Issue a mandamus directing respondent number 5 to exclude Vijayanagar district in Bellary district in pursuance of the communication dated so and so Viday annexure L and M. What had happened was, my lord, prior to this election, prior to 21/3/2024 itself, a separate district, Vijayanagara district, was carved out from Bellary. Now the name of respondent number 6, as your lordships notice, is a cooperative societies union consisting of Raichur, Bellary, Koppal and Vijayanagar district milk producers union.
Yes.
Therefore, the society had sent a proposal to the society made separate voter list district wise. It had sent for approval. It had also sent for approval the bylaw, amendment to the bylaw, that Vijayanagar district will have so many seats, Bellary district will have so many seats, and election will be held according to that. But in view of this present calendar of events, without making any consideration with regard to that aspect, they issued a calendar of events without specifying any seats for Vijayanagara district. According to them, Vijayanagara district for the purpose of this election will continue within Bellary district is their contention. I would only request your lordships to kindly see Rule 13.
Yes.
Sub-rule 3. Rule 13, sub-rule 3. However, if the bylaws of a society do not provide for such electoral colleges as specified in sub-rule 2b, when the elections to the board of directors of society are due, cooperative election authority is competent to determine such electoral college and notify the same and conduct such election of the society as per the notification issued. Now, your lordship may kindly see Rule 13(1). A cooperative society may, for the purpose of election of members of the board, divide its membership into different groups on a territorial or other basis. In the instant case, cooperative society has divided its electoral roll according to territorial basis prior to the formation of Vijayanagara district. That would be available in annexure, that calendar of events itself. Then, my lord, sub-rule 2, it can be number wise, single seat wise, etc.
Yes.
In sub-rule 3, a special power is granted to the election authority because amendment of bylaw, etc. would take a long time. Convening of general body, proposal, approval, etc. would take a long time. For the purpose of conducting election, it has been given power to divide it. Now, I would request, in this case, it is necessary that election authority should consider. I'm not saying that court should issue a mandamus to do it. Should consider in the given situation how many seats, how it should be divided.
Yes.
That is one of the reliefs sought in the other petition.
Yes.
Please.
Yes, sir.
My lords, I appear for the respondents, the society itself. But factually, just one aspect I must want to bring to Lordship's notice. The term of the committee, Lords, managing committee, expired on 16/5/2024. And elections were to be held on 12/7/2024. But may I now request Lordships to kindly permit me to refer to the statement of objections, 2 paragraphs in the statement of objections.